understood. We have green light, we can start. So welcome to the Edge, second day, and oh, that's the wrong sequence of my animation, never mind. So yesterday I talked about our duck and the sort of conversations we could have with our duck, not only when doing debugging, but I think when writing a scientific article, it might be nice to explain to the duck what you're trying to say, might help. And now I want to talk a little bit about the t-shirt. So there are two things being said on that t-shirt. And it's presented as if this is a cubicle thing, and it definitely is. But the author of these two quotes, because they're quotes, quote is more than law, quotes is less than law, is actually with us. And it's a person, it's not a group. It became a group, but it's a person. And this is Laurence Differ's open access book, Jurisprudence. So jurisprudence in continental Europe is case law, what in the rest of the world we call case law, but in the UK and United States, jurisprudence is what we in continental Europe call legal theory or legal philosophy. Jurisprudence means thinking through what happens if you digitize the law in a very broad sense. And two of the chapters in that book have in the title, Code is more than law and code is less than law. So it's also a reflection on something that has been with us for a very long time. Law is Lessig, code as law, law as code, etc., etc. But this goes, I think, honestly speaking, a bit deeper. So I want to say the t-shirt is not just for fun, but it's a direct indication what sort of books you don't have to buy because it's open access. Then I want to say something else, and I will do that also in the wrap-up of the conference. So this is Brussels. Brussels is, I think, for people who live in Brussels, known for a lot of local, small and medium-sized companies that we work with. Yesterday, I talked about the funding of the conference. Now I want to talk about the companies that we hired, thanks to that funding, of course, to do our conference. I'm going to put up a slide at the end of the day of /Line, who's doing our visual support. We're very happy with the way that's happening. And Choux de Bruxelles, who is taking care of the catering. This is the company that has taken care of the t-shirts. So it's organic, it's fair trade, etc. And we love that this is local Brussels. This is important. So we're not talking about big tech sponsoring us, but us sponsoring small and medium-sized entrepreneurs. Okay. What about the edge? So let's think again in terms of graph theory. Graph theory is a mathematical theory, but it underlies the analysis of social networks. So the way social networks are run is partly based on graph theory. And I would invite anybody who's interested in legal text and AI more generally and how the back end of these systems work, to have a look at what graph theory actually is about. Graph theory thinks in terms of nodes and edges. And the edges are simply the connections, the relationship between nodes. And nodes can be people, organizations, or any other object. And the relationship can and is often, for instance, frequency. So in network analysis, you see a visualization with all these edges, the lines, and they usually refer to frequency or intensity. Why frequency? Frequency is, of course, meaningless. The fact that there is a connection very frequent, does that mean anything? I don't think so. That depends on a lot of other things. But you can measure it. So let's look at what we can measure instead of what matters. That's one of the issues we want to table here. So what is the edge between the two nodes of this conference, yesterday and today? The edge is, and it happened sort of spontaneously, that the last keynote of yesterday was about how could we assess the impact of these kinds of legal technologies. And though our typology would have been presented yesterday at 2 o'clock, we switched and it's presented now. And actually, we were stunned at what Emily Bender was telling, because you will see that in the typology, we sort of follow in part what she did, or she followed us, but that's not possible because she has no foreknowledge. I want to just very quickly remind us of the objectives of the conference. We are all very happy with the way things are going, so we are all hopefully learning from each other, listening, the bottom line is that we want to get our hands, our fingers, behind the upstream design decisions of these systems and the downstream impact. And for instance, I think I missed my train this morning because I answered to a tweet of one of the people present here. When I was finished, I looked up and it went off. So I think that the AI Act is very important because it suddenly requires such an assessment for AI systems, not for AI. AI is a research domain. It encompasses all sorts of things. Besides that, AI, of course, doesn't exist. It's a PR term, and there's a history to that. But as soon as you integrate such a system and you want to make a profit, okay, then you will have to suffer the consequences of that. You will be made liable. And there's a lot wrong with the AI Act and with any legislation because it's not perfect and not trying to be perfect. But I do think that's very important. So part of the typology that we will be presenting is about how could you assess these sort of upstream design decisions in terms of impact. And we have looked very specifically at the impact on the law and the rule of law. We're not taking the Anglo-American harms approach. It's not about harm. So Emily Bender talks about harm because that's utilitarianism. We're not doing that. We're saying, does the constitutive framework of our society, how is that affected by this? This is today's program. You can all see it on your smartphone or your laptop. It's all there. And this you already know. And that means we're now moving to the next presentation, and that is the start of the presentation of the typology. I'm going to briefly introduce it, and then the three people who have been working extremely hard in finalizing it based on the work of an entire team. So we would need the next PowerPoint now. Based on the work of an entire team, those three people are going to present the content, the working of the typology. And I'm just going to introduce it as soon as I have that PowerPoint on. Okay. I'm sure there is work being done to put this on. Little introduction then. So this project is on what we would call in Dutch grondslagen. Grondslagen van het recht. How is the core of the law and rule of law, constitutional democracy, affected by these sort of tools? And actually, we're not doing empirical research. What we're doing is looking at the assumptions that have to be made if you want to build computational systems. How, based on those assumptions, certain implications are inevitable. So even if you don't do empirical research, this is where the constraints sit. And of course, one of the assumptions is that things are computable. And I've already talked about you can make anything computable, but if you make something computable, you don't have the thing itself, but you have its computable representation or proxy. And that has many implications. So we've been thinking and talking about that for a long time. We read ourselves into a lot of philosophy that was relevant. And at some point I got the feeling we need to now ground this in what's actually happening. We have to look at legal texts, specific legal texts that are either papers, scientific papers with proof of concept, or applications that are toy projects with which you can play around with everything being posted on GitHub, or commercial projects. Take, for instance, Westlaw Edge, which the whole of the United States is using. We also looked into data sets because they are the condition of possibility to develop machine learning systems, to develop predictive legal tech. And we looked, for instance, in domain-specific languages, programming languages, like Catalan, to see what sort of more general purpose technologies make this possible. And we spent, I think, 3 or 4 months with weekly discussions with the whole team, with the computer scientists and the lawyers together, in what sort of mapping should we do, which questions should we ask, and then how should we put that into a tool that is easy to navigate. It is clear that the presentation has gotten lost, by the way, so I hope somebody will come back and say, can you resend it? And that means we have thought very carefully about all the different questions you could ask about such technologies. Just to give you an example, a toy example. So one of the questions we ask is what is the background of the authors or developers of this tech? Which jurisdiction? So in computer science, there is no jurisdiction. Yeah? Computer science is computer science. It's not that if you're in the United States, you do a different type of computer science. Though now that I'm opening my mouth and saying that, I'm sure that Emily Bender will disagree with me for very good reasons. Nevertheless, this is a global domain where, let's say, the idea is that mathematics is the same everywhere, and computer science and the development of these systems also. So there is no keen attention to jurisdiction, and the idea is that if you can develop something that you started developing based on one particular jurisdiction, but you can universalize it and then apply it everywhere, that is great. From the perspective of democracy, that is not great, because we want to be ruled by our own law, not by somebody else's law, and also not by a sort of an adaptation of somebody else's law. Anyway, now we have the presentation, so let's go through it. I'm going to say something about the who, the what, the how, and the why will come at the end. So the who, this typology is being published now. It's becoming publicly available. So we're all very curious about comments. It's going to be public not only in this jurisdiction, but at a global level, of course, because we're putting it out on the website. And it's a publication. We think it's a publication. It's not in a journal. It's a publication online. You will see that this is a different sort of animal, but it's a publication with authors. So Laurence, Pauline, McBride, and Masha Medvedeva, they are going to present it. They did the final work over the past year, enormous amount of work. But the whole team worked on it. Arjun Banerjee, Eva Dont, also a computer scientist, Tatiana Duarte, Sarah Dushi, Gianmarco Gori, Emily van den Hoven, Paulus Mason, computer scientist, and myself. And this was the law team and the computer science team collaborating and trying to get this conversation going with a very practical output, which forced us to sometimes compromise, to be able to not be complete. Because if you want to do a typology, you can't be complete. So the idea is, why are we making that? For whom? For an academic audience, yes. But in the first instance, for courts, law firms, for the legislature, for regulators, for bar associations, law societies, law schools. We used it in a master course that we gave in Tel Aviv international master. And it had great results because it forced the students to actually connect with real legal texts and to ask salient questions. Of course, it's also going to be very relevant for legal search. CS practice in academia, developers of legal technologies and computer science, and of course, citizens, NGOs in advocacy or activists around fundamental rights, and companies. So what is the typology? It's actually a set. Typology means you think in terms of types and tokens. And the tokens basically define the type, and the type defines the token. So this is not a taxonomy. It's not trying to be complete in any way. So we have 30 legal texts, that's the tokens, that are concrete applications, scientific papers, or data sets, and they're categorized in terms of 8 types. Intended users, is this tech developed for academics, for in-house lawyers, for litigators, for instance? Is it code or data driven? And we have defined what we mean with that. What is the form? Is it a component? Is it an application? Is it a platform? Is it meant to automate decision-making in law or to support decision-making in law? Is it in use or not? What are the creators? Are they academics? Are they in-house lawyers or tech developers? And there are many categories, other categories, of course. The jurisdiction is one of them. And access, how can you access it? Is it open source? Has it been put somewhere in a repository? Is it licensed? Is it service, software as a service, etc., etc.? So these are the types, and of each tech, 2 questions are asked. What is it claimed to do by the people that provide it, that offer it? What is it claimed to do? What is the intended purpose or the claimed functionality? And intended purpose is, of course, aligned with the AI Act. Now you could say, and the second question, oh my dear. The second question is, now that we know the claim, and those claims are based on what is made public about those systems, and we quote that with archived websites, how can these claims be substantiated? Can they be substantiated? Are they being substantiated? What gap is there? And what does that gap mean? So this is where the really hard work set. Now you could say, okay, there are already so many taxonomies out there, and now you're going to make another one. So that's not our purpose. We're not trying to be complete. It is out there. We're not going to update it. That's not the purpose. The purpose is to provide a methodology, a way of approaching these texts. So you could say to people in a classroom, you could force people to actually engage with it and study it, and then say, okay, now take your favorite legal tech and try to answer the same questions, and then discover whether you actually can, whether you can figure out whether this works or not. And then think about what it means if you cannot. So it's not a taxonomy, it's not about completeness, it's not about mutually exclusive categorization, the favorite of analytical philosophy. It's much more interesting to look at the types and to then see, so make analytical distinctions, but to then see how they actually overlap, because that's very important. So that means they are analytical and not ontological. So an online tool that affords to map. First exercise is to just map. What sort of stuff is this? Then to compare. So if you have one type, we have a couple of them. How do they compare? In what do they differ, etc.? To see at a glance, and they will show you what a particular system is about, to see what they are claimed to do and how this can be substantiated, to obtain an understanding of how the system operates at the back end. That's, of course, key. And then for the person, the user of the typology, how do you do that? By way of filters. So you can play with it. You can use different filters and shift and say, okay, now I want to see this sort of, well, it's all going to be demonstrated in a few minutes. You have all sorts of click-through options. So you say, what is this about this terminology? I've never heard of it. Why? You can click and you get a banner with a very brief explanation. I'm now talking about mostly the computer science terms. And then you can go further and you get a bigger explanation. You get scientific references and easy to read references. So you get all sorts of links to brief explanations and relevant technologies and relevant scientific literature. And this is going to come back at the end. So I'm going to stop now and leave it to the people who develop this further.
Okay, can we change to my laptop, please? Yes. So we've been talking a lot about this thing, the typology. We've been hinting about it. We've been dropping like teasers and all this stuff. And here finally is the actual end product. We launched it this morning, about 25 minutes ago. It's now public. You can view it yourself. We'll give you the URL towards the end of this presentation. But I'm just going to run through some of the design choices we've made, the features that it has, and hopefully you can get a very intuitive sense of what it's for and what it can do for you. So the initial interface is this filtering interface, as Marie just described. So you can see the 30 legal texts, these tokens. They're all classified in different ways. You can play with them. You can change the filters. You can think about how they relate to one another. It might be surprising that certain things overlap in ways that you didn't expect. So what it gives is a kind of overview, a kind of bird's eye view of the legal tech landscape. So by playing with these filters, you get this sense of what's going on. And then you can choose a few. You can click these little boxes here, and then scroll to the bottom, and you have this high-level comparison of them. Do a few more. And then you get this kind of sense of a bird's eye view of the kind of, let's say, hesitantly say, the objective characteristics of the systems in question. Now, this is the bird's eye view. So this is the homepage. It gives you that sense of the landscape. But what we really want to do is then to drill into the systems, to see the depth of the information that we've gathered about them. So for that, each token, each legal tech has its own profile. So I'll just choose one. I'll go for Lex Machina, which is quite a well-known US-based legal analytics platform. So in the profiles here, you have the same information on the right, this kind of high-level bird's eye view. Then we've got a whole plethora of stuff that we've gathered, that we've synthesized to make sense of in terms of the questions that Marie was just discussing. And you'll see some parallels here with what Professor Emily Bender was talking about last night, the kinds of questions that have to be asked by the people who are considering implementing these kinds of systems. We're attempting to answer those questions here, all in one place. So first of all, we talk about the claims that the providers make. We do a high-level description of what the system claims to do, including these kind of little embedded descriptions of some of the technical terms, and I'll explain a bit more about that in a second. So we have the high-level description, and then we break down the claims into their essential features, the rationale and benefits, and the design choices, all about the claims made by the providers. Not claims made by anyone else, not claims made by us. We are taking the information that they have published, that they make public, and presenting it to you, distilling it for you in this form. Now, what we've done with these bullet points is we've necessarily had to distill down the content of what they've said, but we don't want to put words in their mouth. We don't want to misrepresent what they're saying. So at all times, what we've done is we've provided full quotation of the sources that we've used to develop these summaries. Everything is linked back to its original source. Everything is archived and dated. And that's important because it shows that it's a snapshot in time. We're not, as Marie said, we're not purporting to keep this up to date. We're not purporting for this to be a kind of live catalogue that will forever be completely up to date. That's not the purpose of it. It shows that there's a snapshot in time. It shows the kinds of the content that resulted in the answers to the questions that we have derived. So question 1 is this idea of claims. And then we've got question 2, which goes into the deeper, more technical and legal philosophical questions here. So the question of substantiation. Do the technical claims that they make stand up from a technical perspective? Do the legal claims that they make implicitly or explicitly stand up to a legal critique? And this is all synthesized by us in one place. Masha is going to go into more depth into one of the profiles, so I won't do that right now, but you get a sense here of the amount of synthesis that we've done. And the idea really is, because we're a team of both computer scientists and lawyers, this is not just a bunch of lawyers looking from the outside critiquing these things. This is computer scientists who understand the technical underpinnings, critiquing it from the internal perspective of their discipline. And then us, as lawyers, as legal philosophers, also critiquing from the internal perspective of our discipline, which is the red box. So the profiles are there's lots of stuff in here, as you can see. We highlight the technical issues in the yellow boxes, legal issues in the red box. Again, everything is quoted, everything is archived. So we want to be as fair to the providers as possible. We don't want to misrepresent them in any way. We provide academic sources. We provide links to repositories, to data sets, that kind of thing. So it's really a one-stop shop, as it were, for the particular systems that we've looked at, as well as being a broader methodology. We've then got these other questions, but I won't go into them in any depth. But you can see here that we've synthesized a lot of information. We've tried to make sense of a very fractured, very heterogeneous legal tech landscape, and to put it into this kind of form in a way that we're asking the same questions of every system. So we've done this synthesis almost so that you don't have to. So that's the profiles themselves. But what's interesting here, or what's also interesting here, looking back at the little these things. So these are little definitions of the technical terms, which are particularly useful for people who are browsing the typology who don't have a technical backgrounds and may need a brief overview of some of the terms that are used. Now, these terms we have written ourselves, or I should say the computer scientists and the team have written themselves, and they are also part of this website. So the terms are automatically brought in from our vocabularies. We've got two vocabularies. And in the computer science side, we've got two vocabularies, a code-driven vocabulary and a data-driven vocabulary. These consist of a whole set of terms which define at a high level the kinds of concepts that we're dealing with here, the kinds of underlying technologies which are represented in the legal text that we're dealing with, together with additional reading and examples of the kinds of text which are relevant. So there's a whole trove of information there, and that's complementary to the typology tool itself. And then, of course, we have our working papers, or so far one working paper, which is a legal philosophical look at the nature of text, the role of text in the practice of law. And this is also something that we've connected into the typology. So some terms in the typology will be linked to the vocabulary, other terms will be linked to the working paper. And the idea is to create a kind of web that operates at multiple levels. So if you're more legal philosophically inclined, you can get what you need from the working paper and you can marry that to the typology. You can see a practical application of it. If you're more technically inclined, you can look at the typology itself, connected to the computer science vocabulary, for example. So there's a whole bunch of different things going on. There's a whole bunch of interplay between the different aspects of this thing, and the idea is that it's no one product. It's kind of a living thing, which is going to be useful for lots of different people in lots of different ways, and we can't foresee that. And that's part of the power of this. I think that's part of the value of what we're producing here. What's important, I think, is also, in addition to this substantive tool that we've built, the substantive content of the tool that we've built, is also to think about the methodology. And Marie hinted at that in her short presentation there. We've got a whole page on our approach and our methodology, how we actually did this, why we did it, the method that we developed over time, and it did take a long time to do this, which is very much a cyclical thing that we developed over the course of many, many months. So that's worth reading in itself, even if you're not interested in legal tech per se. There's a methodological aspect to the typology, which is about how you actually perform this kind of research, even if you're not interested in the content of the typology, the form of the typology, how it came together, the thinking behind it. And a lot of deep thinking went into this, and this page is really helpful to explain that. We've also got a couple of exercises on the how to use page, which is a good taster for people who are coming to this completely fresh, have no idea what it is, maybe a bit bewildered about what it's for. This is a good tool, a good resource, I think, to perhaps think about how it might be applied in your own work, as an educational tool perhaps, but also as a training tool potentially for people who are in industry. So what I'm going to do is I'm going to pass over to Masha, who is going to give us a demonstration or look a bit more closely at one of the profiles in a bit more depth.
Indeed. So I work a lot on predictive core decisions, so I choose when I choose the tool that I'm going to review, one of them is indeed working on predicting core decisions. But so I want to look just at one of the systems and go through more specifics of what the actual claimed features were and sort of how we analyzed and what we did there. So this paper was published in 2017, this academic paper, and actually got quite a lot of success. It was cited quite a bit, and this is one of the earlier papers on predicting core decisions using machine learning. But this was actually not the only topic that it covered. So the paper talked about predicting the legal domain within the French court cases. Then it predicted the time period in which those judgments appeared, and then it predicted the rulings itself. And this is something that is claimed in the paper. There's quotes here that demonstrate that, as Laurence already showed the functionality. And then they also have some rationale behind decision of doing that, and most of it was a proof of concept and trying different things. But they also, for instance, suggest that this system would benefit law professionals by providing guidance and decision support. They don't really specify what that means, but this is something that we look at and then we try to see, okay, can it actually do so later? And then there's some design choices about the systems in general, and then they all, for instance, use support vector machines, and this is also something that if you don't know what support vectors machine, you can go and have a sort of high-level explanation of what it is. This is more aimed at non-computer scientists, because I would assume that computer scientists know that. So then each tool will have potential legal impact. For this tool, for instance, this is something that we started discussing yesterday, but basically this paper doesn't provide a way to actually predict a court decision, so it might be misleading for policymakers and whoever wants to use that. I will not go too much into the legal impact, because this is I'm more qualified in the technical part, but basically let's look at one of the tasks. Specifically, I want to focus on identifying the law area of the court decisions that the paper claims to be doing really well. So we can first look at the data, what they have. They have quite a lot of French court decisions, more than 100,000 cases. And for each task, what they do is they take the final judgments of the decision and take out the information that relates to that label. So for instance, it will be final judgments in a specific law area, and everything that refers to that law area will be taken out of that judgment. And this is the data that is the input of the system. This is what they describe in the paper, and they use words and combination of words as input. And as you can see, they get almost 97% accuracy for 8-class classification. Fantastic result. However, when we actually try to look at what they're doing and why they're doing this, there is immediately a lot of issues, as you can see for a long yellow box. So, for instance, the authors say that by removing these terms that relate to the law area, they provide a simple, a realistic draft case description scenario. I'm not a lawyer, but to me, a case where all the arguments are already in it, the judgment was made, and just the words that refer to specific law areas, a time period, or the outcome is not a realistic draft of a case. This is already made judgment and a very sophisticated document. And specifically for this task of predicting law area, if you take a final judgment and say, okay, this is not a judgment, this is just a draft with all this information. If you came up with a document which already has all the arguments of the court and the outcome of the court, it is very unlikely that you would not know what the law area is of this judgment. So it's also not surprising that they get such a high accuracy, but we also sort of question what is the purpose of this, right? In what situation will you end up that you do have those documents but do not have a law area? And because of how the system is built, it requires this input. It requires the input of this draft. So it doesn't provide any way of, for instance, as somebody who wants to go to court to figure out what the law area they should go for. So this is really, it provides for a very pretty picture of what somebody can do, but it doesn't actually provide anything functional that can be used in AI law. And this is, I don't want to seem like we cherry picked this paper and said, okay, they are doing like this really bad research. They're not. This is really representative of the field of NLP and prediction in law. So my background is predicting court decision. This is also what they do. They just take basically for predicting outcomes, they take the final judgment, just the words referring to final judgment from the case, but they still have the argument of the court and so on. And in what situation would they still would have arguments of the court, have all the information about the case, but not know what the judgment is? And in which situation would you want to have all the court arguments, and then, okay, but now let's predict what the actual outcome is. What is this situation? So this is, again, from the perspective of analyzing, predicting court decisions, it's very representative of what is out there. So, and you'll see that in the typology, we have different tools there, also commercial ones that also, like you would think that like in a commercial system that they would avoid that because they have to actually predict something to sell it to their clients, but this is not true. This is very often the case that this happens. So what I want to demonstrate here is sort of how we go through it and how we really try to understand what different aspects of the data, of the algorithms are, and how based on just the publicly available information, we can see whether they're actually doing what they're claiming to be doing. I really enjoyed actually last night's presentation by Emily Bender, because the questions that she questioned each case based on are very similar to the ones that I had on the window, like just on sticky papers while I was working on some of these tools. Because we really try to also see whether this is appropriate, whether this is ethical, who will suffer from having such a system, and so on. But now I'm going to give the floor to Pauline to talk about sort of the future of and the future use of the typology.
If you have questions,
There you go.
please signal me.
Let's do that. Okay.
So now the typology is live in the world. What future do we hope for our typology? What do we think its value is, not just for us, but more broadly for the research community, for lawyers, and for computer scientists? I'm going to hopefully outline a little bit of what we hope for our typology. As you've seen in our typology, we have a free, publicly accessible resource which groups together both code-driven and data-driven examples of legal tech, both legal tech described in papers and commercial applications, both historic and current examples. We've already realised the value of the typology in the context of, as a resource in the context of our own publications, and we hope that it will prove to be a trove for other researchers. However, the typology, as you've seen, not only provides examples of legal tech, but examines the claims made by the developers, the information that they make available to substantiate their claims, and it identifies potential technical issues. But really crucially, it instantiates a way of thinking about and critiquing legal tech, which is sensitive to the impact of legal tech on law and legal practice. And so we see an important role for the typology in the education and training of lawyers, computer scientists, and others working in the legal tech space. For lawyers especially, and it's easy as my background is in law, I practiced as a lawyer. So for lawyers, we hope that this means that teaching and training based around the typology will be integrated both into pre-qualifying training and, just as important, perhaps more important, post-qualifying education delivered by universities, by law societies, by bar associations, by the judiciary and by others. And Mirai has already mentioned that Laurence and Vrije delivered a course based around the typology earlier in the year. Some post-qualifying, those of you who are in practice or have been in practice as lawyers would know that some post-qualifying education really can amount to little more than a pitch about the legal tech. Training based around the typology, on the other hand, would provide a different perspective and balance. But we hope that the typology might actually empower lawyers by providing a better understanding of the range of the technologies, the techniques they employ, their capabilities and limitations, and perhaps most importantly, their impacts. We hope it will encourage lawyers looking to invest in legal tech to question the vendors about how the systems work, whether and how they can substantiate their claims. We hope it will prompt greater reflection on whether, in what contexts, and with what safeguards these technologies should be used. When you look at the typology, you will find that in some cases, we've discovered that the developers and vendors provide very little information, even high-level information, about how the legal tech systems work. We hope that the typology might support calls for greater transparency in that regard. Transparency has been a recurring theme of the conference, and we hope that the typology will lend itself to requests for greater transparency about legal tech. But the typology, as I see it, is also highly relevant for discussions and regulatory initiatives concerning lawyers' professional obligations relating to the use of legal tech. I have in mind, for example, the guidance provided by the Law Society of England and Wales concerning the use of law tech, or the Law Society of Scotland about the procurement of IT, or the Council of the Bars and Law Societies of Europe concerning the use of AI by lawyers. Our hope is that the typology will encourage lawyers and the regulatory bodies to take account of the impacts, for better or for worse, of types of legal tech in the context of use. Computer scientists and developers understand that the systems that they develop must meet the requirements of their users, but we also hope that the typology might contribute to a deeper or a more nuanced understanding of those requirements, taking into account not only questions, say, about speed or ease of processing or other performance metrics, but the actual context of law and legal practice. As you've heard, we don't suggest that the typology is the last word in legal tech, addresses all conceivable issues, or, since that's not the aim, is complete in its coverage. But we do hope that it meets a need for a framework for exploration of the implications of legal tech, and both articulates and exemplifies a need for deep dialogue, and this conference is obviously contributing to that, a deep dialogue between lawyers, computer scientists, and others working in the legal tech space. And with that, I'll hand back over to Vrije.
Well, thank you very much. Maybe you can understand that this is a historical moment for us. And thank you very much. It is, of course, not at all the case that this is all we have been doing these 4 years, but it's been extremely nourishing to work with actual text and not just in the abstraction, at the high abstraction level. And this is what we really need to do, I think. And I also want to thank many people, some of who are here, with whom we discussed these legal technology and who gave all sorts of advice, both computer scientists and lawyers. So now, of course, I can understand that it's overwhelming because this is not a tool that you can just look at for a minute and then say, oh, it requires some appetite, I think, also. And we hope that by embedding it in these vocabs and by doing it, and thanks again very much to Laurence web development here. So by making it, let's use that fantastic commercial term, user-friendly, giving it a wonderful user experience to appetize you and to draw you, not into a rabbit hole, but into the depths, because there is a lot inside. So now we're very curious about questions, and we also hope that, and I'm also saying that to the online audience, that not just now, but that later, when you actually go in deeper, that you're going to come back. I'm not sure whether we have opened the comments section. We have on our website at the research blog a comments section, but we'll probably be opening that. It's open. It's all done. Because this is going to be very valuable, not in the sense that we necessarily now going to revise the entire typology, but that we learn, okay, this is not getting across, and it might take some time. I think the tool will serve best in a training environment, so where one-on-one in small groups, you really train people how to access it. But of course, it's also very important for other people that it's publicly available on the web so that they can use it and develop these sort of trainings. And we're going to be available for giving these sort of trainings. It will be part of the project also. So I'm going to now go to the floor, and somebody is checking the chat, I hope. Yes. Oh, fantastic. Yes. So I have Pauline. I'm not sure about your first name. Maurizio, yes. And I every time forget your first name. Robert, yes. Robert. And Katie. Caroline.
So
Caroline Kaufman, private law.
I had a
asking
question about the tool dealing with French decisions. The first element, I think that the decisions of the French Code de la Cassation are very easy compared to other decisions to translate or to get information from, because they have a very specific structure. They mention the legal provisions that are at stake, then they mention what the court has said, and then they mention what the law is, and then they draw a conclusion. So that is a structure that you always find back, and it's easy to know at which place of a decision you find which kind of decision, of information. And then about your question or to the developers, or your criticism to the developers, that you do not know why it would be useful if you have all this information to predict what field of law they relate to. I was wondering whether this could not be useful in the process of classifying all the case law. Most legal systems are now putting all their cases, or in the EU, are now putting all their court cases online, while in the past that was only a very small proportion of the cases. And all these cases in France, it's tons of cases, they need to be classified according to specific fields of law so that they can be easily searched. Would the tool not be useful for this?
So I have two answers to this question. First of all, so the analysis of this system is in the frame of what they're saying they will be doing. And they are saying they will be predicting it for these cases and so on. And so this is what the analysis in the typology will be. It will be related to this specific system, right? But it's a valid question of what you're saying. The problem is that the way that they do it is they first mask the area of law, which they do automatically, which they do by just searching for terms. So this is how you could already know what the law area is. So you have this very complex machine learning system, which is not necessary for this. It is not to say that sometimes for different law areas that it can be quite a complex system. I worked with eviction cases, finding eviction cases in the Dutch case law. It's a hard task. And then sometimes you would maybe want to employ machine learning. But this is not what this paper was about. And this is sort of, here we go over each tool and really look at that tool specifically. But the way that we highlighted, we hope that you will, like, if you were to come across a system that does something like what you suggested, that you will be able to ask these questions about it. So I think this was a good example.
I think that what Masha is saying is that they claim that they are predicting something which is absolutely not true. They're not predicting anything. They are categorizing, basically. And Masha actually wrote her doctorate thesis on this, that many systems that claim to predict have, due to what is called data leakage, the prediction is in the data, so it's not a prediction. Now, what you're saying is very interesting. You're saying, why not use it for classification? And that's exactly her point. So that is the outcome sort of her thesis. What they're doing is not predicting, but classifying. So what she's saying what we are saying in the typology is, okay, this is sold as a prediction. What it actually does is classify. Now, this is what lawyers need to know, because then lawyers can say, and it's also what she says in her doctorate, oh, this is a great tool to classify, to map. But it's not predicting, and it's a waste of money to buy it if you want to use it for prediction, and very dangerous, because you're going to say, so somebody tells you, tomorrow I'm going to drink coffee there. Somebody tells you that, and then you sell a very expensive tool with a lot of machine learning, where you predict that they're going to have coffee there tomorrow. Yeah. So this is what she's calling out. Arvind Naranajan and Kapoor have just posted a paper on Archive. So these are Naranajan is a well-known Princeton computer scientist, where they investigated a whole series of not legal text but other machine learning predictive stuff, where they say that in the majority of the cases there is data leakage, which means that nothing is predicted. And they say this is part of the reproducibility crisis in machine learning. So Masha actually published her thesis 9 months ago, or now, or the article that is relevant here 9 or a year ago. And this is now being confirmed, not just for legal tech, but for, let's say, a large part of the domain. And this is important. Lawyers have to learn that that there is PR and where the PR sits and where these systems are actually making sense. And that is what a typology wants to do. So no, it doesn't do that, but maybe it could do that. And I think as lawyers, we are adversarial. We're trained in saying, oh yeah, you're saying that? Well, good, let's anticipate whether that's correct considering these arguments. So we should use that adversarial attitude when we look at these texts. And I think we're going to be very helpful also in terms of assessing claims about these systems. Sorry, Maurizio.
Switch on, yes. Thank you very much. This is a beautiful piece of work. I have 3.5 almost questions. I'll try to be concise. So first, absolutely not in a pejorative sense. Am I simplifying too much? I'm trying to categorize your software in my mind. Am I simplifying too much if I think of it as a review of systems organized in a beautiful, highly usable interface with a lot of work behind, because each one of that sections means that somebody read the paper, understood the paper, and wrote a comprehensive review of that single paper system, whatever it is. And am I simplifying too much if I say this is such a big review system with the 2 main dimensions being the typology and the token? This is the first question. Second, what are the criteria used to choose systems papers to include in it? And now I'm asking if one can apply, or if one publish a paper. And of course I'm asking because I would like to apply our future paper to be written yet. And then, since I think this is very, very useful, if one can propose to help in somewhere in the review system. I mean, I don't have yet the skills probably on the law part, but maybe I could think of some help in the computer science part, for instance. And then, since this is such a beautiful piece of work, you said in the beginning we are not proposing to keep it up to date. That's really a pity. I would suggest you do. I understand that this means compelling yourself to a lot of work, but if you organize things in such a way that people can send you the papers when, I mean, if this becomes a good reference for the computational law community, I mean, it's just a suggestion. End of questions.
Very good questions.
Yeah,
Great.
fabulous questions. And actually, your second one relates to some questions in the chat, so hopefully we can bundle those together. The first question, is it just a review? In a sense, yes.
Not just. Yeah.
In a sense.
Yeah.
It might appear that way because the end result might seem, I don't know, there's an awful lot of thinking has gone into the end result. So it's not like a literature review, it's much deeper than that. If you read the methodological pages, you can see that we've really thought about the kinds of questions that needs to be asked, which ones are relevant, which ones are not. There's so many other things we could have put in here, but we didn't. And that was absolutely intentional. So that's the first thing. The second thing is also, we're lawyers, we tend to write things. We tend to write reports and articles and books. And do you know who reads these reports, articles, and books? Absolutely no one. So the medium here is the message. We talked yesterday a bit about that. The idea is to make it accessible to people who otherwise might think that sounds great, but would never open the book, would never download, or they would download the PDF and it would just sit forever. So we want to make it accessible. We want to allow people to share links to it, to make it fully accessible, like it works on devices, blah, blah. People who are busy, who are in practice, they don't have time to sit and read a report. They can go straight to this page. They can get a high-level view. They can get a sense from the vocabulary about the relevant technical terms. And I think that's really powerful. So the medium is part of the message. The fact that it's online is not just a whiz-bang thing. Oh, look at us, we're so modern. It's partly to practice what we preach, which is CRCL, cross-disciplinarity. If we're just lawyers writing as lawyers for lawyers, that's not cross-disciplinarity. So the form represents what we're trying to achieve, which is proper communication between domains. So that's the first thing. The second thing, in relation to the selection. So this is a very, very good question, and it's quite a philosophical answer to that question. Again, it's something that we thought about a great deal. Central to the themes of this conference is the notion of legal effect, which is not necessarily easily graspable, either by lawyers sometimes, or certainly by people outside of the domain in many cases. Legal effect is the thing that we're really interested in, the deep concept that we're interested in, both in Cubicle as a project, and I hope in this conference more generally. So if that's the thing that we're interested in, what that does is it creates a frame, as it were, to think about the systems that should be in the typology and the systems that shouldn't, on the basis of what we've come to describe as the effect on legal effect, right? So if you've got, I'm not going to go into, this is not a lecture, if you've got the concept of legal effect here, then what we wanted to identify is systems that would impact that concept. That's it. Now, there's an answer to that is huge, but that was the filter. So you've got lots of legal texts which don't do that. They are like back-end systems which mean that the operation of a law firm is more efficient, it's cheaper, something like that. That doesn't meet the threshold that we were interested in. That doesn't mean that they're not important. That doesn't mean that they're not worth analysing at all. We're not suggesting that. But what we had to do is, we're a small team, we had to define A, what our interests were, and B, which systems would qualify under that. And this idea of the effect on legal effect was the kind of the lodestar, as it were, that we used to apply to consider which systems would get in and which systems wouldn't. So that was the first thing. So there's a bit about that in the methodological page, so it's worth reading that to understand what I mean by that. So I don't want to go into it in depth now, but it's the fundamental question as to what's in it and why. So that's the first thing. The second thing is we didn't just want to look at systems which were brand new, because as has been mentioned in the chat, and as we all know, legal technology is not new. We've got 40, 50, 60 years of it behind us. So we wanted to represent a broad swathe of historical systems, all the way up to the present day, all the way up to things which are being developed right now. So we want to be fair insofar as possible to the historical development of legal tech. We want to ensure that different types of systems are represented across code-driven, data-driven. We may want to contest those two categories, but we want to represent different forms of legal tech in terms of the underlying technologies, in terms of the intended users, in terms of the intended functionalities. So we want to do all of those things, cover all of those bases, as it were, always under the umbrella of the effect on legal effect. So that automatically closed down the scope. So you may accept that as a methodology, you may not accept that as a methodology, but that was our methodology, and we're clear about that in the methodological page, and we're going to write much more about that because it's so important to what we're trying to do. On the third thing, you talked about adding new systems. This is an interesting question as well. I think for the same reason, if we were ever to contemplate adding systems, I'm not sure we are contemplating that or will contemplate that, but if we were to, they would have to reach that threshold of the effect on legal effect, because that, again, is the core that we're interested in. But secondly, and it kind of goes to your first question, the development of the profiles was not straightforward, shall we say. It's not you read the paper and then you just summarize it. You'll see when you actually read what we've done is that you have to dig out the parts that matter, and then you have to do a bit of thinking about how they refer or how they relate to state-of-the-art technical approaches, how they relate to legal theory, how they relate to the rule of law. So every profile was not just a summary. It's not a literature review. I must emphasize that. The typology is not a literature review. It's so much more than that. So to add a new system is not a small undertaking. So practically speaking, it's not a straightforward thing to do. But also, as Marie said, this is a methodology. It's not just a catalogue. So our point is not just to provide a load of substantive information about existing systems. It's also to give people a way of thinking about future systems and other systems which are not included. So the goal that we have is to, yes, provide substantive information, and there could be more in there, there could be less in there. That's certainly true. But our real goal, I think, in terms of the cross-disciplinarity, in terms of future impact, is to provide a way of thinking about these systems, a way of critiquing them, and a way of identifying the kinds of problems they might have and articulating the kinds of questions you need to ask to identify those problems. And you need to ask them of the providers of the systems. So that's what we've tried to do. So it operates on a substantive lower level and on a meta, more philosophical level, but don't want to use that word because that implies it's not practical. It is practical. So I hope that answers your questions.
Yeah, two small additions. So it's about types. So if we have a couple of systems of the same type, then we are actually done. Unless a new type would appear, then we might have to update. So it's not a taxonomy. It's not trying to map all the systems of the world. And basically now it's up to others to see how new systems fit in the typology, etc. Also, the typology is also connected with the conceptualization in law, like the concept of legal effect. I think I talked about it in the keynote yesterday. So legal effect is not causation or something like that, or reasoning. It's this performative effect. It's a very special animal. And we have a set of foundational concepts in the legal vocabulary: legal subject, legal right, legal obligation, legal norm, legal effect, positive law, rule of law. So these are constitutive of the domain. They're not interesting concepts or something like that. If you don't get those concepts, any of the other concepts like tort action, contract, you cannot understand. If you don't know what legal effect is, then you don't know what a contract does. So this all fits together, and it's an approach where you think in terms of types and not in terms of trying to solve the whole world conceptually or something like that. That's in no way what we intend to do or think would make any sense. But I think the key questions have just been asked, and check the methodology, because we'll probably have to keep explaining why we made these decisions, because it's the first question that comes to mind. Why these systems, not others? When are you going to update it, etc.? Should we have a question in between of the chat? So the person after the break has let us know that he's going to be a little bit late, so we have to snoop a little bit of that person of the break into that. So I have still two questions, Robert and Katie, and then maybe the chat.
I think there's two questions in the chat currently, which I can just read out and then you decide to react on it.
Yeah, maybe
they're very fast.
Let's input the online audience then for a minute.
Okay. So Lyria Bennett Moses asks if the tool is contestable or fixed. Hypothesis is disagreement about the description or classification of a tool. And Mathieu Tulknik asked how easy was it to find a common language between legal scholars and a computer scientist in the team? And thank you for the questions on the chat. Keep them coming.
So the first Sorry, the first question was, is it contestable? Well, we are lawyers, so anything is contestable. So we have a comment section. Yes, you can comment and say, I would describe it like that. Of course, that would require that you pay the same sort of attention and do the same sort of study in depth of the system. But I think it would be very interesting and important to do that. It is fixed in the sense that we're now moving on to other things, definitely. But we would be extremely interested in any contestation. The second question was what? Because I thought...
was it easy to find a common language?
Oh, yes,
between
yeah. Well, that was very easy because that's the opposite of what we try to do. So that's what we want to avoid. We are not interested in shared language. So the term legal effect has a meaning within law. And if you try to corrupt it by explaining it in a way that it makes sense within computer science, we are very far off home. And I'm always using the same example, and it happened again yesterday. Optimization is a mathematical term which has a very precise meaning in computer science. Of course, you can now talk about optimization as a utilitarian might like to do in social science, talking about cost-benefit analysis. Yeah, that's a very different meaning of the term. And what we want to do is to avoid that sort of, throw the terms in a cooking pot, in a melting pot, and then stir and say, oh, we're doing such lovely interdisciplinary research and now we all understand each other. No, then everybody will go home and say, oh, thank God I can do my own homework again, and people know what I talk about when I say legal effect. So our goal is to help computer scientists understand legal effect, that it's not about causality and not about logic. I've had that conversation very often, and it's nearly impossible to get that across. Also because lawyers never talk about legal effect, because it's in their blood, in their DNA. You're trained in the practice of law and you know what is legal effect, but that doesn't mean you can explain it. That was very easy to answer. No, it was very easy, yes, because that's the opposite of what we want to do. And I think I've said that yesterday morning. I think it is the first thing we write on all our websites and on the journal. And I feel that people read it and think, oh, yes, that's interesting. And then after that, they go to somebody else and say, this is a key project. They're developing a shared vocabulary. So it is in our common sense, in our grammar, it's how we map the world. You want to have funding from the European Commission or from somebody else? Well, say that you're collaborating with computer scientists and developing a shared vocabulary, you'll get lots of money. Why? Because it will distract from all the real problems and you can get busy and talk and blah, 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 blah. We have to get to the real research and try to understand what optimization actually does in reinforcement learning, what a loss function is. What is a loss function? Is there anybody in the room that can explain to me in 3 sentences what is a loss function? Yeah, I can see somebody is beginning to do that, yeah? So now a sociologist might say, oh shit, that's mathematics, and that's about curves and multidimensional systems. But I can think of what it might mean from my perspective. Now, this is what we warn against. Don't do that. First figure out what it does in machine learning. And I'm telling you, then you have a razor-sharp blade to say this system doesn't do what it's solved for, but it's doing something else which is very dangerous. Or which is great. That's also possible. Robert.
I would like to also point out that we do like each other and we work very well together.
We love each other, yes.
Well, I had this question, but I really need to comment on what you just said. Because I'm a bit puzzled about this fear for a shared language. I can understand you don't want to have a shared language, especially with computer scientists, but I would say it would be a really great thing to have is that not only lawyers can talk to each other about the meaning of the contract, but that the contractees know what it means themselves, and that they don't need a judge or a lawyer to understand it. And if we have such a common language that involves parties of interest, then computer scientists can go into that and say, well, okay, this is the domain we have to work with, and how can we contribute to that? Because in my opinion, making stuff computable or automizing it is very easy if you know what you're doing. And if you don't know what you're doing, well, then it's going to be a problem. And that's what we've been discussing for the last day. So that was the comment on what was just said. And furthermore, I really would like to congratulate you with your great work. I was a bit disappointed that it's not an idea yet to keep it going and working on that, but maybe we can find a solution for finding an initiative for that, because I'm involved in a project for the Dutch government that is setting up a website on how knowledge-based algorithms or rules are being used by the government, and it includes also information on tooling and methods for doing so. And I sent the link to the person that's in charge of that project, and his reaction was cool. So, well, maybe we get to talk about that. My comment on the instrument, and I've been looking a little bit, so maybe there's more into it already than in my first impression. I think that the category of code-driven tooling is maybe a bit conflated. So I think it could need some more differentiation in what exactly is meant by it. And Giovanni was talking yesterday about this natural text-based approach. I think that would be a great addition. But making categories in what is code-based, what you mean by it, and what different approaches are there, it should be really helpful. And I also got a comment of the person who was involved in creating the regelspraak solution, which is in the model as well. And she was a bit disappointed that it was categorized as an app, while in her mind it was firstly meant to be a method, a standardized method for looking into legal text, well, primarily on tax law, but then potentially also usable in other fields of law. Well, that was my comment and reaction.
Yeah, very briefly. So the argument about what language you speak and how you use words. So the example you give, that you want computer scientists who are developing something to really understand what they are working with, what they are targeting, means that they should understand how lawyers use words. And that means you don't need a shared language. You need to understand how they use the words. And that's a very different thing. So if we're going to make a definition of optimization that works for both computer science and law, for instance, then it's going to be meaningless, because the meaning is very different. So we need understanding. And that means you have to make the effort of how such a word functions, what it does. And I totally agree with you. Lawyers actually don't talk about legal effect. So this is an observation based on a lot of literature, of course, of what lawyers actually do when they apply the law. And when you conclude a contract, you don't say, oh, I'm contemplating the legal effect of buying this piece of bread, right? Thank God we don't have to do that. So law is very much a practice of people. And this is precisely what we want to respect. And then, of course, if you go to court, then the language of the law will appear. And that language is not ordinary language. And there is a hugely impressive and interesting discussion whether legal language should be less specified and closer to ordinary language. And if you study that literature, the conclusion is the moment you do that, a lot of legal protection will fly out of the window, because you will end up with very vague, flexible terms. So the law is flexible, yes, open texture, but it's not so flexible that the meaning flies out of the window and everybody can put in what they want. So for the law, if you define a term, you define who gets protected, under what conditions. And if a computer science is not willing to look into that, they should actually not build this stuff. So shared vocabulary simply doesn't work. If a chemist, for instance, defines an atom in a certain way, and now we're going to do shared meaning of atom between lawyers and social scientists and chemists, then the chemist will say, okay, go ahead. But when I go back to my domain, I know exactly what I mean with that. And the others will not know what we're talking about. And that's what we want to avoid. So if you mean with shared vocabulary that we're going to better understand how we use terms, practice understanding of language, I totally agree. But that's not shared language, it's the opposite. And I can feel that this is a very difficult point. Very briefly about the updates. So I love what you're suggesting. This is what we want. What we're saying is we're not going to continue to add tokens because that's not the function. So others can take another token of the same type and propose a new type and do the same type of investigation. That's really what we want and hope for. And we would love to give trainings to the ministry, to European Commission, that's working with Laos, etc. So that's our goal. But it doesn't mean that we're going to now spend time in going for some sort of completeness that is, if you do science, you want to categorize, right? You want to catch some things under a certain heading. Unless you're a nominalist and think you have to describe each individual instance to make sense, but that's not science. So what we try to do is categorize, typify, and then we hope that people pick it up and do the next thing. But I think your comments are spot on again, and we'll have to explain this again and again. And maybe the simplest solution is to every time when somebody makes this argument to say that we are developing shared language because we want people from different disciplines to understand each other, and then everybody will clap because we use the right common sense idiom. And I want to change that common sense. So maybe we won't do it. Katie.
Thanks.
We have to have a break. Yeah, so we'll take a question and we will not answer it. How about that?
It's fine because it's a little bit repetitive anyway of one of the previous points, and I'll make it quick. Thank you for the efforts in building this resource. Congratulations on achieving it. My question was along the lines of the maintainability, and I wonder if you can distribute this by reaching out to other community groups or by even, say, having an annual event tied to a conference. Another edition of this conference, ICALE, Eurix, you put a call out for people to... I noticed that, yep. I didn't want to put too much pressure on you. I did notice you'd already envisaged a future edition because I'm sure you will become victims of your own success and people wanting to have this maintained. And I just wanted to encourage outreach to other communities and groups to distribute the help with that maintainability.
Thank you. Right, let's take 15 minutes. We're shortening the coffee breaks. We've overran a bit, but we've got our speakers are here and available, so let's do this. 15-minute break. Coffees.